on eviction moratorium, how tenants in Houston can protect their rights. Thank you for making the time because this topic affects many of our clients and community members. The Alliance is proud to co-host this event with the Houston Immigration Legal Services Collaborative and the Houston Volunteer Lawyers. Events like these align with our work as a whole, and particularly the Alliance's newly launched Center for Resiliency, where we help community members build resilience to prepare for and overcome life's unexpected challenges so they not only bounce back, but also bounce forward. This is done through disaster preparedness and recovery, legal assistance, behavioral health services, mutual support and learning, plus resilience and outreach activities. During the presentation, we would like to ask you to remain on mute as there will be time for Q&A after. And you're welcome to post questions in the chat box during the presentation, and we'll make sure to get them answered during the Q&A. The meeting will be recorded, and if you want the recording or link to the video, please let us know by adding your email to the chat box. And we'll also be sharing the video on Facebook and YouTube. And now I would like to hand it over to Lisa Everett, who is staff attorney with Houston Volunteer Lawyers, and she leads their eviction defense project. Lisa.
Thank you so much. Thank you everyone for coming today. I'm here to talk about the CDC eviction order, which is an eviction moratorium that is supposed to go into effect tomorrow and then expire December 31st. It came out, it was sent out late Tuesday. It's supposed to be published, which is, like I said, when it goes into effect tomorrow. And that's what I'm mostly going to be talking about today. In case you haven't read it, I'm going to post, and I don't know how this is working on Facebook Live, and I hope someone from my organization is posting this also, but I'm posting the link to the actual CDC order into the chat box right now. And I can also share my screen in a little bit. Sorry, I'm having an issue, Pat, posting it. So this is the link to the actual order. It's long. The part that is the crux of it, though, and what we're excited about is at the end of it, it says that if you give your landlord a declaration, they're not allowed to do anything that, I'm going to get the wording wrong, but leads to an eviction event, essentially. So texaslawhelp.org, which we think is a really, really great resource for everyone for a lot of situations, has a page, and I am putting that link in the chat box as well. And it is a summary of what the CDC order is. It also has a link to the actual declaration that tenants can use to give to their landlord. And I'm posting that in here too, but that link is on the texaslawhelp.org website. But I want to go over what it says. Basically, it says in order to be qualified for the CDC protections, you have to be a residential tenant, and so not commercial tenants. And it also, in some areas, it's going to depend, like if you live in a hotel, are you covered under this? The general, in Texas, generally, in order to be a residential tenant, you have to be living in a residential tenancy. Generally speaking, hotels are not like a residential tenancy in Texas. You must be behind on rent. This is an eviction moratorium only, I shouldn't say only, that's aimed at non-payment of rent. It lists certain, so if you're being evicted for other violations of the lease, it doesn't cover those sorts of evictions. There is a debate going on right now. If you're behind on rent and your landlord is evicting you for being a holdover, if you're at the end of your lease term, and then if no one renews, you're considered a holdover. Generally, you just get to keep paying rent month to month. If a landlord is evicting someone only as being a holdover, even if there's unpaid rent, any advocate should make an argument that it's a pretext for the non-payment of rent and not really a holdover eviction. That's our position. That's the National Housing Law Project's position. HBL takes that position as well. But in general, it's just, I just want to make it clear, it's aimed at non-payment of rent cases. And then there's a couple of requirements for the tenants as well. One is that it says you must have made their best effort to get government housing assistance, including applying for rent government housing benefits, or any other program that may be available in your area. For this, whenever anyone calls HVL, we're recommending that if they have not already, and even if they have, to call 211 to try to find rental assistance. To our knowledge, that's the best way. 211 should direct people to all the various organizations, including the Alliance. I'm thrilled to hear that y'all offer rental assistance also. But government housing benefits is generally like Section 8. Those waiting lists are closed right in Houston, Harris County, the Harris County Housing Authority and the Houston Housing Authority. Those wait lists to become a voucher, recipient are closed right now. I guess you could go and say, like, I went to the website and looked that it was closed, but there's no way to get that sort of rental assistance in this area right now. I'm not going to speak for the rest of the state or the rest of the country. This is the CDC, so it does apply to the country, just by the way. One of the other requirements is that for the year, you must earn less than 99,000, for 2020, or 198,000 if you're filing jointly, or you don't have to report any income to the IRS. You didn't have to report any income in 2019, or if you received an economic stimulus check. Those are the financial qualifications. You also, on this declaration, have to certify that you're unable to pay your full rent or make a full housing payment due to substantial loss of household income, fewer work hours, layoffs, or medical expenses that are likely to exceed more than 7.5% of your adjusted gross income. Another requirement is that you have to certify that you're doing your best to pay your rent in full or in part. And so some landlords won't accept partial payments, but you have to have made an effort according to this to do what you're able to do. And then the final leg of the certification is that you have to certify that you would become homeless or live in a shelter or other crowded space, like going to a friend's or family's houses, if you are evicted. And then it also has a notice that that the person signing the declaration understands they're doing so under penalty of perjury and could be subject to criminal or civil penalties if you're lying on this. The final really, really important thing is that it must be given to the landlord. If the document is not given to the landlord, then you're not covered under the way it's written in the CDC order. So it has to be given to the landlord in order. It's not just that you have to qualify. It's not some like, oh, I qualify. You have to get the document, you have to sign it, execute it, and you have to give it to the landlord. And so I'm seeing a couple of questions. And how does one prove that they try to get this kind of rental assistance, or do they? It's a certification. We don't know how this is going to be challenged or not. We're planning on using these as defenses to evictions, writs of possessions, or any stage of the eviction process starting tomorrow. I also do want to note that generally speaking, we're expecting lawsuits to try to stop this order from going into effect or staying in effect. So we don't know how long it will be enforceable, but while it is, we will definitely be trying to do it. So it's the declaration. We don't know I think if someone says, I called 211, then that's proving that you tried to get government assistance. I encourage people to call more than once, because if someone needs rental assistance, normally that need's not going away. This eviction moratorium does allow for the accumulation of fines, fees, and penalties. The CARES Act moratorium said that, if you're a covered property, the landlord wasn't supposed to charge you late fees and things like that during the period that the CARES Act was in effect. But that is not the case in this order. It specifically says that the landlord can't evict you for it, but can charge you late fees and penalties. So I do want to make that clear. The checklist is actually in the declaration. Like, the declaration actually says all of these things, and it's also in the texaslawhelp.org page on the CDC order. And I think it's a more readable checklist than maybe going through the CDC order, because it is lengthy. But the actual declaration itself is just one page long, and it has these requirements in it. So someone asked, tomorrow, would I recommend that if they're eligible, they get these? Yes, if they're eligible, they should do it. If you're behind in rent, I think you should definitely do this if you're behind in rent starting tomorrow. There's one more thing I really want to push. I think that it is important for people to know about this resource because I don't know that everyone does. I spoke with someone today who is supposed to have a writ of possession executed against her tomorrow. I called the constable's office in that case because I heard a story on CNN that Harris County is not going to execute writs of possession starting tomorrow. I called the precinct that she was in, and they said that as of tomorrow, anything that's outstanding, they're sending back to the court. I do want to qualify this. I think that this is all dependent on no stays or no court actions going into effect that prevent this order from becoming effective. But yes, I do recommend that. But the other thing I really do want to recommend is if you have any client who's facing an eviction, like who has received a notice to vacate, I really do recommend that they seek legal assistance. Houston Volunteer Lawyers is really lucky in that we work with 4 other organizations in town. We call ourselves the Eviction Defense Coalition. It's Lone Star Legal Aid, and it's also the 3 law schools, South Texas College of Law, the University of Houston, and the Earl Carl Institute at Thurgood Marshall School of Law. We're all working to defend evictions in Houston, and any one of us can help most people that are going to qualify for your services. If one of us isn't able to, we will definitely make a referral to another one. But I really do recommend that anyone who is facing eviction to seek assistance. We don't expect for landlords to just say, oh, there's a CDC order and you gave me a piece of paper, now I'm not going to file an eviction. We don't think that that's going to happen. We know that landlords filed evictions in violation of the CARES Act. We know that covered properties filed evictions against people who were supposed to be in protected properties under the CARES Act. And we do not think that landlords are going to say, oh, good, there's a CDC order and not file evictions. And so we really are recommending that people still seek legal assistance so that they can protect rights, so that they can protect their rights. The other issue is that the tenant may not know what all their rights are, and an attorney can help find what rights they may or may not have. I'm going to go through some of the questions right now. If an eviction has already been filed against a client prior to today and they have a court date, will they still have to go? Yes, because yes, still go. 1, because we don't know if this order is going to stay in effect. And 2, because I don't know how different judges are going to treat it, because it has to be given to the landlord. And so it's not the judge's job to say, hey, landlord, did you get one of these, a copy of one of these orders? You should definitely go to court and say, Judge, I think that the CDC order applies to me. I gave a copy of the declaration to the landlord, and here's a copy as well. The other thing, I listened to a Facebook Live yesterday from Lone Star Legal Aid, and they had a very nice suggestion about when you're giving something to a landlord. If you're not doing it in a way that can be tracked, like with a fax confirmation sheet or maybe an email or a text message, and if you're doing it in person saying, like, here's this piece of paper that I'm giving you, almost everyone has a record function on their phone now. Texas is a one-party consent state, meaning as long as you're part of the conversation and you consent to recording yourself, you're allowed to record the conversation. And you can record the conversation. It says, here, landlord, I gave this to you. And that can be proof that you gave this declaration to the landlord as well. So I just do want to point that out. I believe that this applies to every stage of the eviction process. I believe it applies to the notice to vacate. I believe that it applies to, it should stop a landlord from giving a notice to vacate. I believe it should stop a landlord from filing an eviction. I believe it should stop an eviction from being granted. And I think it should stop a writ of possession from being issued or prosecuted. We don't know how judges and courts and landlords are, if they all feel the same way though, but we believe that it applies to every stage of the eviction process. Should you get a receipt? If you can get a landlord to say, yes, I received the declaration, by all means do that. I don't think that most landlords will do that. Another way to do it is to send a certified mail, so you have a tracking number or return receipt requested. I also think that if you can show that you email back and forth with the landlord and emailed it to the landlord, or that you texted it to the landlord or some other ways, I I like that. But some proof that you can show that you gave it is always nice. There are supposed to be penalties against landlords who violate this as well. I don't know if the Department of Justice is actually going to be prosecuting that, but there are supposed to be penalties against landlords who violate this order. And so, yes, I think that having some sort of documentation that you did this is important, so that if violators are prosecuted, there can be proof that it was given to them. So I'm looking right now. This moratorium is not a deferment of rent. It is not a rent cancellation. Rent is still owed. One thing about this entire, since the pandemic started, anything that's been put in place, nothing has forgiven rent. Rent, as of today, rent is owed, has been owed, and will continue to be owed. I know that there are some people who are criticizing this order because they feel it's just kicking the can down the road, because people who aren't able to pay now are just going to be left with an even bigger burden come January 1 when this order expires. The Eviction Defense Coalition, I would like, if one of my coworkers can post in the chat the phone numbers or websites of where people can apply. So Houston Volunteer Lawyers, they can apply online. Anyone can go to makejusticehappen.org and use the apply online. That's the best way to apply with us right now. Our phone number is also 713-228-0735. I don't have the number for Lone Star handy, but I hope that my coworkers can post that. And I also hope that they would post the phone number for South Texas College of Law and the Earl Carl Institute as well. So I apologize. It's not, even though we are working together to try to come up with strategies to help defend what's happening in our area, we've also started a pilot project in Precinct 7 and Precinct 2, in which people who are served evictions in those courts get a phone number to call, and it goes to the coalition, and we're doing a right to counsel in those courts. So, but other than that, if you haven't gotten the number from that court, it's best to contact each organization individually. And I think, to my knowledge, everyone is fast tracking eviction applications so they don't sit, so hopefully everyone can be helped as quickly as possible. So, so undocumented families, there is no requirement in the order that I've read, and I haven't read anything that prevents any undocumented families from receiving protection under this order. So I believe it does protect undocumented families. I know that many undocumented families are not eligible for all forms of rental assistance or couldn't get the economic stimulus check, but it's still, if they're under 99,000 of income, or 198,000 for a joint for a family, then they should qualify financially that way. Just so y'all know, I do believe that. Okay, so someone is saying that if you're in San Antonio, call St. Mary's School of Law Housing Hotline, and their phone number is 210-576135. And my coworker, Mari Carmen, is posting the phone numbers to the other legal aid organizations in the Houston-Harris County area. And Lone Star actually does serve a larger area. They do serve a lot of the Gulf Coast area, not the entire Gulf Coast area. And I know the Earl Carl Institute at Thurgood Marshall does serve surrounding counties as well. So if you have people outside of the Houston area, there are other legal aid organizations. And you should encourage anyone in any part of the state to reach out to legal aid in their part of the state. I'm looking for more questions. Does anyone else have, does it apply to federally backed apartment complexes? This applies to everyone. So it doesn't matter whether or not you have a federally backed apartment complex or whether you are, you know, a regular Joe who has a couple of rental properties. It's supposed to apply to every single residential tenancy. It's supposed to apply to everyone. It's very, very expansive and very, very broad. And I'm looking for more questions. I'm trying to go back up because I think I missed a few at the beginning. So I know that someone, I'm just scrolling through. We don't think that there should be a standard guideline list of what counts as best effort to get rental assistance, because we don't want the person who tried to get rental assistance but didn't do as much as the person next to them to be denied relief under this act. And so there are no guidelines, and I do expect that to be a reason why some landlords or judges might push back, but there are no guidelines at this point. But anyone who's coming to you for landlord-tenant issue should be referred to 211 anyways for rental assistance. Anyone who's having trouble paying rent should be referred to these organizations, to these two organizations who can potentially assist with rent. And I'm scrolling down again, excuse me. I don't know what, I know that there's the Housing Stability Task Force in Houston, and there's also a Supreme Court task force, Texas Supreme Court task force that does bring together housing advocates and landlords. Someone did ask if there's communications regarding the facilitation. I have not heard reports from what's happened from either one of those yet, but I guarantee you that there are communications taking place at some levels in some of these task force that include both, groups. So but I don't know beyond that.
Lisa,
Yes.
I want to add that HVL is doing some training this week with our organizations that are trying to facilitate that type of communication. So there are different organizations that will be working on that in the near future. I also wanted to point out, Lisa, there's a question about how the 30-day written notice to vacate plays out in all of this. Do you want to touch on that just a little bit?
So the 30-day written notice to vacate is from the CARES Act. The CARES Act says that if someone's in a covered property, and a covered property includes any property with a federally backed mortgage, and that basically means any government agency touches your mortgage, you're covered. It's the servicer or the lender or the investor. And it's more than Freddie Mac and Fannie Mae. I just want to make that clear. It's also FHA, USDA, Veterans, Ginnie Mae, any government organization. It goes beyond the two. And that can be a single family residence or a multifamily unit. It also includes any property that has any tenant subject to VAWA. And so that's most commonly for most of our people coming to us as either going to be a Section 8 voucher recipient. It can also be people who live in LAHTC properties, low-income housing tax credit properties, housing for the elderly, and housing for the disabled. There's more than that. I'm only listing a couple. Of course, publicly owned properties, from Houston Housing Authority as well. Anyone who is getting a notice to vacate from a covered property for non-payment of rent, or anyone who's getting, notice to vacate is supposed to be receiving a 30-day notice to vacate. I believe that this act means that they're not supposed to get that notice to vacate, or if they don't move out at the end of the notice to vacate period, that they are not supposed to be filing an eviction against people who are in properties covered by the CARES Act.
There's a question from Facebook. Does this apply to mortgages?
No, this does not apply to foreclosures, and it's actually spelled out in the CARES Act that this is not a mortgage foreclosure prevention.
Someone asked, how about if someone has just lost an eviction court case Friday before moratorium was signed?
Then we believe that you should give a copy of this declaration to your landlord and seek legal assistance to request that there be a temporary restraining order to prevent the enforcement of the writ of possession, or to say that no writ of possession should be signed or served. You know, like they should, that if a landlord goes to court to request a writ of possession, that the judge should not sign it. And that if one has already been signed, to get a temporary restraining order to prevent it from being, you know, served and executed. And that's something where lawyers can help a lot if they have already lost and the landlord is still trying to pursue a writ of possession.
And speaking of landlords, someone asked, has there been any communications with the landlord organizations to help facilitate communications between tenants and landlords?
Like I said, I know that there are some organizations, like, you know, at the Texas Supreme Court Task Force, I know that there are, like, the General Counsel for Houston Apartment Association, as well as representatives like from Lone Star Legal Aid are both on that organization. So I know there is communication, high-level communication.
Is there a list of accepted documents or other proof to demonstrate eligibility, or is it vague?
It's vague. There is no list, and we're not advocating to create a list because we don't want to create a list that makes some people ineligible for various reasons. Some people don't realize they're qualified. Some people aren't aware of resources, but anyone who's coming to you should be referred to 211 to request some sort of rental assistance.
And if a tenant presents the CDC declaration, does that absolve landlords from repair issues?
This has nothing to do with repairs. In Texas, under the Texas Property Code, it says that if a landlord receives a request for a repair, that they're not required to make the repair if rent is unpaid. And this does nothing to address that. This is a national order, and it doesn't mention repairs at all. In general, in Texas, if rent is not paid, the landlord does not have an obligation to make a repair.
And then someone asked, is there a graphic timeline of the eviction process? It would be good to determine how the CDC directive may be applied at each step of the process.
We think it applies to everything. I can very, very quickly go through it. So first, there has to be a breach of the lease or something that entitles someone to say this, that the landlord says, nope, the tenancy is ending. And so what happens then is the landlord is supposed to give a notice to vacate. Under Texas law, it says that you have to give 3 days notice to vacate unless modified by a contract. The standard Texas Apartment Association contract and the Texas Realtors contract requires a 24-hour notice to vacate. If the person is living in a property that's covered by the CARES Act kicks in, and that's supposed to be a 30-day notice to vacate. But other than that, most people get a 24-hour notice to vacate. When the notice to vacate has expired, that's when the landlord is allowed to go file an eviction. When the eviction is filed, the constable serves the tenant and they receive their court date. The court date happens. After that, the tenant has up to 5 days to appeal from JP Court. It is 5 days. If it falls on a weekend or a holiday or a day that the court closes before its normal like closing hour, then it goes to the next day. But tenants should not play fast and loose with that, or they're like, oh, I should, you know, I was going to go at 5 o'clock and it closed before I got there. Like, you are SOL. The time to appeal is 5 days. On the 6th day, or the day after the time to appeal expires, the landlord is allowed to request a writ of possession. If a writ of possession is requested, the judge signs it. It goes over to the constable's office. The constable comes and gives a 24-hour notice that they're going to come back the next day and execute that writ of possession, or they say what time they're going to come back and do it. If you are not gone, then they can physically remove you from the property. If someone appeals, that can be done using something called a statement of inability to afford payment of court costs or an appeal bond. If you appeal within 5 days of filing the appeal, if it's a non-payment of rent case, you also have to pay rent into the registry in order to stay in the property during the appeal. But if you appeal it, it goes up to county court at law, and you get a whole new trial to prove whether or not all the rules were met. But in order to stay in the property for a non-payment of rent case, rent has to be paid into the court registry when you file the appeal and monthly as it becomes due. And I think that there might be, I'll see if, I don't know if we know who's on this list or not, but the Texas Justice Training Center has some flow charts of just how certain processes work within the justice courts. It is possible they have a flow chart of the eviction process.
Thank you, Lisa. And just let everyone know this event is slated to end at 3:30. So in respect to everyone's time, I just wanted to let you know that it's 3:30 right now. And I see that there's still a number of questions that are unanswered. So Lisa, if it's okay for you to continue.
I'll continue.
Okay, great. So there's a lot of questions about how to show to prove that they've tried rental assistance. And one specific question is, if we are operating a CARES Act funded rental assistance program and the tenant receives confirmation that I apply to the program, does that give them the proof they need for landlord?
If you want to give any proof, you can, but this declaration doesn't require that any proof be attached. It's a declaration. If a landlord wants to challenge it, I believe it's going to have to be challenged in court. I hope that landlords don't file it, but if someone's having an issue and the landlord says, I want proof, this declaration actually doesn't require proof. There's nothing wrong with a tenant saying what they did if the landlord is challenging it. But like I said, some people are going to, I don't want to say be neurotic, I don't want to use that word, but some people are going to be more tenacious than others. And maybe they're going to be calling every day, but there might be someone else who's still struggling to go to work, still struggling to educate their kids, and can't call 211 or some other organization every single day. And they shouldn't be held to the same standard. It doesn't require proof, but if you're giving this to someone, they should understand that if someone asks them, they should be prepared to maybe say what they did, but it doesn't require proof. It's a declaration.
Okay. And then someone asked, are there organizations that can give a presentation to community members about these housing rights, preferably in Spanish? And I see that Katie had mentioned that Catholic Charities is providing presentations in English and Spanish. What about HBL?
I don't know. I have to speak to one of our Spanish speaking attorneys.
Well, I'm actually working on both of those presentations. So we are coordinating with other organizations to assist. And we do provide trainings and information as part of our individual outreach, organization outreach.
Someone just asked if the Q&A from the group chat can be posted. I don't know how to do that. And I'm not the one running this, so that's someone else's.
And for now, we hope that a recording of this video would have the questions and the answers. And we can also share this via email.
Okay, I see that it was just posted.
This order applies to all evictions, correct? Not just for non-payment of rent?
No, it is for non-payment of rent evictions. Okay. There may be, like I said, we believe if you have a legal advocate, and if we believe that someone is trying to evict you under the pretext of something else, you know, and they're used like if your lease is ended, and instead of just accepting your monthly rent, if they're saying, nope, your lease ended and I'm evicting you for being a holdover, and they don't mention anything about unpaid rent, we would argue that they're using that as a pretext. But just be aware, and the Lone Star presentation I attended yesterday said you should be aware of the relationship you have with your neighbors and maybe your landlord. You know, like if a landlord wants to come in and you haven't been paying rent for a while and they know about this order and they don't want to, you know, risk any fines, maybe they come in and say that you've been a really, really noisy tenant and they're evicting you because you've been breaching other provisions of the lease. The CDC order actually says it doesn't apply to other violations of the lease other than non-payment of rent. And so just people shouldn't think that this is a get out of jail free card. It's not. And they should be aware, you know, don't antagonize relationships at this time so that people can find other reasons to possibly evict someone. This is supposed to apply to non-payment of rent.
And then someone asked, what if they have been filed against the client prior to today and they have a court date, will they still have to go?
Yes, I think we answered that one. I think that they should absolutely go because the judge doesn't know that if you don't tell the judge I gave this to my landlord, you're not covered. You're not covered if you don't give it to your landlord.
And then questions, has HAA commented on order or has TAA said anything?
I have not checked their websites.
Okay. I don't see. I don't see any other questions remaining. Is there any final thought, Lisa?
If you're helping someone who's experiencing issues with a landlord, please encourage them to apply for legal assistance. There are a lot of resources available, and we're all working really hard to try to make sure that everyone is helped.
Great. Thank you so much, Lisa, for this very useful and informational presentation. We really appreciate you, and thank you everyone for joining us today and for posting your questions. And we will make sure that we send out the links for those of you who requested it. Have a wonderful day.
May I say one last thing?
Please do.
If you're a private attorney watching this and you're interested in volunteering, please email evictionvolunteer@hvlp.org. Again, that's evictionvolunteer@H for Houston, V for volunteer, L for lawyer, P for program.org, and we will get you signed up to help someone who's facing an eviction.
Thank you. And eviction volunteer at hvlp.org is in the chat box. So please sign up and volunteer because the need is great, isn't it?
Yes, it is.
Great. Well, thank you so much, everyone. Have a wonderful rest of the day. And we look forward to future opportunities to share resources.
Thank you so much.
Thank you.